I'm Matt Pichard with NAREITsREIT.com here in Washington, D.C. at the Marriott Marquis for NAREIT's 2016 REITWise conference. Joining me is Sonia Barros, Assistant Director with the Division of Corporation Finance with the Securities and Exchange Commission. Sonia, thank you so much for joining us.
Thank you, Matt.
Now, how would you describe the overall disclosure record for the REIT industry, and how does that compare to other industries?
Before I say anything, I do have to make the standard disclaimer that the views I express today are my own and not those of the Commission or other members of the Commission staff. With respect to REIT disclosures, at the SEC, we do recognize that REITs are different from most operating companies and different from companies in other industries. Because of that, we actually have specialized disclosure requirements and forms that only apply to REITs. For example, we have Form S11, which calls for specific disclosures about material properties and property operating data in registration statements. We have found that many REITs, most REITs actually also provide this disclosure in their annual reports, not just for material properties, but also on a portfolio basis. And it's our understanding from discussions with investors, analysts, and market participants that they find this information extremely useful.
And for those unfamiliar with the process, can you tell us a little bit about a typical REIT filing season? You know, how does the work get apportioned among staff? How many filings do you review? What's the overall process?
Well, certainly as a public company, anything you file with us could be reviewed. Typically, though, we are most likely to review your annual report, your proxy statement, and if you file one, your follow-on registration statement. With respect to annual reports, we are required by the Sarbanes-Oxley Act to do a financial statement review of every public company at least once every 3 years. But we actually do more than that. We do both legal and accounting reviews. We also review many companies more frequently than once every 3 years. With respect to follow-on registration statements, those may or may not be reviewed, and they go through what we call our selective review process. Generally speaking, you can expect to hear from my staff, the staff in the REIT group, whether or not your registration statement will be reviewed within about 10 days of filing. In terms of staffing, we, at the SEC, within the REIT group, we have a team of accountants and lawyers, and we are dedicated just to the review of REIT filings. But as we complete our reviews, we also do use the other resources we have available to us in the Commission. So, for example, if we have a particularly complex or novel issue, we may consult with other specialized offices within the Commission, such as our Office of Chief Counsel or our Office of Chief Accountant.
Through this review process, have there been any REIT-specific issues that have emerged this year?
We have certainly seen an increase in use of non-GAAP measures other than FFO. And in the REIT group, our comments on these other non-GAAP measures have had a couple general themes. First, we sometimes find that we will issue comments on the reconciliation from GAAP to non-GAAP, which is required by our rules. And it's not that we don't see the reconciliation, it's just that sometimes we issue comments requesting additional clarity on what the reconciling items are. So companies may find that they need to provide additional explanations. Sometimes those explanations can be in the form of footnote disclosures. We have also found another general theme. We at times issue comments about usefulness disclosure. Our rules require that where you provide a non-GAAP measure, you also need to explain why management believes it's useful to investors. And so registrants should just keep in mind that these usefulness disclosures cannot be, in a word, useless.
And lastly, any advice or thoughts for REIT issuers as they go through this process?
Yes, I think that issuers should keep in mind that when we issue a comment on their filing or their disclosure, that we're not necessarily looking for additional disclosure in their document. We just may be asking for additional analysis or asking questions because we don't know. So they really should view our comment process as a dialogue. Another thing issuers should keep in mind is that if they're in a situation where they have an analysis on an issue and the staff disagrees with their analysis, they can also ask for reconsideration. The best practice here would be to start off with the staff reviewing the filing. They could always talk to somebody more senior. So in the REIT group, they could talk to a branch chief. They could also talk to the senior assistant chief accountant, or they could talk to myself. If they're not sure who to talk to, we actually also have outlined on our website the reconsideration process, along with both the legal and accounting managers that are responsible for the different offices.
Sonia, thank you so much for joining us.
Thank you.
For more from REITWise 2016, be sure to visit REIT.com.